Hello and welcome to our webinar, Reducing Legal Risk, Protecting Against Claims Stemming from the Impact of COVID-19. Today I am joined by Katherine Brustowicz from the Wagner Law Group. Katherine and I focus our practices on helping companies manage nearly all aspects of the employer-employee relationship by offering preventative and strategic counsel. We also represent our clients in litigation. The program today is designed to help identify potential risks created by the impact of the pandemic on how we manage our businesses. Much has changed over the past several weeks. Suffice to say, it was largely anticipated. So one of the things that we want to focus on is shifting the perception of employers, because perception does matter. View this as an opportunity, an exciting opportunity to take some proactive steps to get ahead of what business looks like in 2020 and beyond. So our agenda today is we're going to talk a bit about the background of the pandemic and its impact on businesses. Then we're going to talk about employment agreements and why some of those may need to be changed, as well as a discussion on compensation. We're going to talk about adverse employment action, both disparate treatment and hostile work environment, how reasonable accommodations are affected by the pandemic, several different issues regarding privacy, and then, wait for it, Katherine and I are going to have a top 10 list that puts David Letterman to shame. So grab your writing sticks and let's get cracking. Katherine?
Sure. So I'm going to talk a little bit about the background here. We know that the volume of litigation tends to closely track economic GDP growth with a little bit of a lag. In particular, companies and individuals tend to raise more lawsuits following recessions based on actions that occurred during the recession. As we're all well aware, economically, our country is hurting right now. We saw the same occur in the 2008-2009 recession. Following that recession, we saw a large spike in litigation based on actions that occurred during the recession. While our current situation is a little bit different from the 2008-2009 crisis, as our current crisis is pandemic-related, by and large, our employment laws are still the same, and employers are still exposed to potential recession-related pitfalls. So today, David and I are going to share some practical tips to help you avoid the risks of recession-related litigation. We're going to focus on changes that have arisen due to the virus and the resulting unprecedented amounts of working remotely. So David, can you discuss some of the risks that telecommuting raises?
Sure, thank you. One of the things that's come up is analyzing employment agreements and offer letters that clients have given to employees. So for example, an employee is given an agreement that says you're going to work for 1, 2, 3, or 5 years. It does not make any mention of what happens if the business is shut down for an extended period of time. And that's something that has happened in many instances. So employers oftentimes don't have protections built into their agreements for something like a pandemic or any other type of an emergency. So it's a good idea to take a look at the employment agreements that you have with your employees, and if you have offer letters that make any kind of representation to a length of time people are working, I think it's time to address that and make whatever changes are necessary. One of the other concerns we have is tracking time. People are working remotely, and many of the people working remotely never worked remotely before. Some are exempt, some are not exempt. How are you tracking the time, and what are the expectations that you're placing on people, especially those who are not exempt? And for example, we've got Gordon, and Gordon is one of those people who wants what he wants when he wants it, regardless of the time of day or night, and he's reaching out to people 24/7. Whenever the urge strikes, Gordon expects immediate gratification, and that becomes an issue. Another issue is when we talk about people being exempt or not exempt. So let's say, for example, you've got an employee who's exempt because the employee, and let's say Stockwell is the name of the employee, and Stockwell manages Jordan and Betsy Barber. Now, that's all well and good when they're in the office, but when they're working remotely, are they still meeting the standards on the Fair Labor Standards Act? So you run into that concern. What they're doing remotely may not be what they're doing in the office, and you may have people who are not exempt anymore if they're working remotely for an extended period of time. And one of the things that we need to talk about is what your workforce is going to look like in May, June, July, and later on. If they are going to be remote for a long period of time, it's very important to make sure that you review those working conditions. Another issue that arises is when people are no longer working in the same state. So, for example, you've got a person who was, let's say, we'll come up with a person named Fielding Yost. And Fielding Yost works in Connecticut and lives in New York. And Fielding Yost is now telecommuting and is in New York and no longer in Connecticut. So New York has got a whole bunch of laws that govern the employer-employee relationship. And there are certain expectations regarding things such as training. There are expectations regarding the paid family medical leave laws in New York that don't exist in Connecticut. So now this person is working full-time in New York State for the company. Does that mean the person is subject to New York laws as opposed to Connecticut laws regarding the employer-employee relationship? These are things that we need to look at. And by the way, another issue would be, for example, if the person is in New York has a unique law regarding what needs to be set forth on a person's pay stub. And it's very specific requirements that exist in New York that don't necessarily exist in other states, such as Connecticut. So these are some of the things that you want to look at to get ahead of issues and get ahead of problems. Hey, Katherine, would you be able to talk about challenges in terms of managing a workforce during the crisis?
Absolutely. So what I'm going to do is talk a little bit about disparate impact and hostile work environment. Disparate impact is sometimes coined as inadvertent discrimination. It occurs when actions, policies, or rules that appear to be neutral on their face end up resulting in a disproportionate impact on a protected group. So there are 7 protected classes under federal law, and those are gender, race, national origin, color, religion, age, and disability. And there are other categories that are protected under state laws as well. Those are the classes that we need to ensure are not disproportionately impacted by actions such as terminations or furloughs. And hand in hand with disparate impact is hostile work environment. Hostile work environment is another discriminatory claim that we need to be aware of and avoid. A hostile work environment is created when unwanted comments or behavior discriminate against a protected group of people, and the behavior unreasonably interferes with an employee's work performance or creates an intimidating or offensive work environment. That includes conduct based on the protected classes that I just mentioned. Now, here's a helpful tip on how to avoid claims of disparate treatment. When selecting employees for layoffs, furloughs, or termination, we need to ensure these decisions are based on legitimate, objective, and documented criteria. It's also important to make sure that we aren't even inadvertently targeting one class of individuals.
Can you give any examples, maybe?
Sure. So, for example, an employer with 150 employees lets go 10% of its workforce. We'll say the firm was comprised of 50% women and 50% men. However, 14 of the 15 employees who are terminated are female. That might result in a claim of employment discrimination. Now, the company may have had a legitimate reason for letting those 14 women go. That reason must be clearly documented and should be reviewed with counsel beforehand. We also need to be careful if actions are motivated by unlawful reasons. Even an altruistic decision to protect employees could still end up being discriminatory. An example might be selecting workers with known health issues for furlough or layoff. Even though the employer is trying to protect the vulnerable employees from COVID-19, it would likely be deemed an act of unlawful discrimination. Here's another tip. When you're conducting furloughs or terminations, keep in mind that every correspondence generated during this process might be seen by a judge and a jury one day. So make sure you're documenting well and be careful of what you keep in writing. Also consider including counsel to keep attorney-client privilege. Keep the protected classes in mind and make sure those classes are not motivating factors in furloughing. When in doubt, please talk to an employment lawyer before you take action. Something else to be aware of is that instances of treating people differently than others are at a risk of increasing during uncertain times. These unequal treatments can morph into hostile work environment claims. People are scared, and sometimes fear ends up being misdirected towards our colleagues. We need to protect our organizations from intimidating, hostile, or offensive conduct. This includes through social media. There's actually been a huge uptick in hostility towards immigrants and Asian Americans recently, and we need to make sure that it doesn't happen in our places of work. My last point on this topic is with a significant portion of the American workforce working remotely, it can be hard to have distinct boundaries between work and personal lives. Employers need to remain mindful of not contacting their non-exempt workers after hours, as David had mentioned. After work hour contact not only gives rise to potential overtime claims, but it could also be interpreted as harassing behavior that borders hostile work environment. David, what happens when an employee working for an essential business asks to work from home?
Katherine, that's a great question. And I think it's important to keep in mind that even though we're in a pandemic, and this is a time that's completely unprecedented for people, and we're all scrambling to adjust, the employment laws that are created at the federal and the state and even local levels remain in full force and effect, and one of those is the Americans with Disabilities Act. And if an employee requests to work from home, and let's say the person's working for an essential business and the essential business is open and the employee makes that request, you need to apply the traditional standards created by the Americans with Disabilities Act, the guidance from the Equal Employment Opportunity Commission, and what's also been described, in terms of some of the decisions coming down from the Supreme Court and other appellate courts at the state and federal level. So the first thing that we need to do is determine whether or not the employee is protected under the ADA or a state disability law. And if it's a close call, it's always a good idea to err on the side of treating the employee as protected under the ADA and then go through the interactive process with the employee. If you're not sure, it's a good idea to check with an attorney. Now, you may want to obtain documentation from a healthcare professional. Ordinarily, when we're not in a pandemic, you can say, hey, give me a note from your doctor that says that with whatever accommodation you're requesting, you're capable of performing the essential functions of the job. Those are ordinary requests made in ordinary times. Now we're at a point where it may not be as easy for the employee to obtain any kind of paperwork from a healthcare professional. You may need to make a decision on whether or not you can go forward with an interactive process and the employee's request without a record from a doctor. Now, the test is, can the employee perform the essential functions of the job with or without a reasonable accommodation? That's the test. And, if the request is for the employee to work from home, then the question becomes, can the employee working from home perform the essential functions of the job? And I think that's where you have to ask whether or not that's something that's possible. And if the employee is going to work from home, what would the cost be to the company? Then at that point, you enter into the interactive process just like you would ordinarily, and make sure that you document the interactive process. A few months before the pandemic hit, I was in court, and the case in front of me in court was a case involving a major hotel chain and a question of a reasonable accommodation. And the judge, asked the attorney representing the hotel what kind of documentation or records they had of the interactive process. And the attorney for the hotel pulled the best Ralph Cramden. For any of you who remember The Honeymooners, and I know I'm dating myself, Ralph Cramden, the character would go, hamana, 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 when he didn't have an answer. So basically, the judge asked the lawyer for the hotel chain, what's your documentation of the interactive process? And the response was essentially, hamana, because there was no documentation. Major company, great legal team, very well trained, all the resources in the world, didn't document the interactive process, but swore up and down that they had engaged in it. So even though you're working remotely, and people are not necessarily in the same room, when you have these kinds of meetings, you've got to document when the meeting took place. Was it by phone? Was it by Zoom or some other type of platform? Was it in person? When did it start? When did it end? What was the request for the accommodation? What was your response? Please document all of this information, all right? And make sure you have a good, safe, and sound way to preserve those records. It will make a big difference down the road. Another important point, Katherine, is that we need to ensure that what we're doing for one person, we're consistent in how we're treating other people with similar requests. So the decisions that are being made regarding these types of accommodations should not be made on an ad hoc basis. Instead, let's make sure that we're centralizing the process and keeping HR in the loop. The last point on reasonable accommodations is when a request is made for an accommodation, that does create an additional protected category in addition to the 7 that you had mentioned, and I refer to those as the 7 deadly sins. And the last one is retaliation. An employee who requests an accommodation due to a health situation becomes a member of a new protected group, and any adverse employment action, furlough, layoff, termination, or reduction in pay could be considered an adverse employment action. And all the employee would need to do is show they made the request for the accommodation within a relatively short amount of time. Something bad happened to them. And by the way, they don't even need to be correct, that they were entitled to an accommodation, so long as they reasonably believed that they did. So, Katherine, I heard that there's been quite a bit of talk about privacy. Can you share some of the things you come across on the question of privacy?
Yes, absolutely. I'd be happy to. So the EEOC's recent guidance, I believe it was from April 23rd, indicates that it is indeed okay for employers to conduct COVID-19 screenings for employees who are entering the office because anyone with the virus possesses a direct threat to the health of others in the office. But we need to make sure that we're remaining mindful of the ADA requirements that all medical information about employees needs to be stored separately from the employee's personnel file. That will limit access to confidential information. And this next point ties back into potential disparate treatment claims. And David, you actually touched upon this, so thank you for doing so. But if employers choose to test their employees, all employees need to be tested. So employers can't just test certain employees. That opens the door for disparate treatment claims. And once the testing has been conducted, employers cannot share employee COVID-19 status among colleagues. That's protected information. So if the employer does do testing and finds out that there is in fact a sick employee, the employer cannot disclose the identity of that sick employee. The employer can let the other employees know that they may have been exposed, but they really need to protect the identity of whomever that sick employee is.
Katherine, that's a great point because that's come up a bunch of times with some of our clients over the last couple of weeks. I'm glad you shared that.
Exactly. No problem. So although employers are not HIPAA-covered entities or business associates, employers that sponsor self-funded group health plans may actually be deemed covered entities. So it's important for employers to be aware of HIPAA's privacy requirements and adhere stringently to them. Now, speaking of privacy, in the context of working remotely, we need to make sure that if we're video conferencing with clients, maybe through Zoom or a different platform, we need to ensure that all parties are aware if the conferences are being recorded. Now, relatedly, we also need to make sure that our personal hardware is set up and is up to date in terms of cybersecurity. So a lot of employees are now working from home, working from their own laptops, and their IT departments from work may not have necessarily ensured that they're up to snuff. So it's our own individual responsibility to do that. And we need to remain vigilant with steps like antivirus scans, and keeping our patches and updates current. And then, of course, we have to remain aware of phishing scams. It's really unfortunate, but it's true that many folks are taking advantage of gaps in our security systems during the pandemic. So we need to be super careful not to click on any suspicious links or anything like that. And if you have any questions, please err on the side of caution and get your IT department involved. David, let's share some proactive steps and tips with our webinar attendees, shall we?
It sounds like a good idea, but when you get back to the whole thing with the phishing scams and, what the scamsters are doing right now, it's a shame that they have such good minds and they're brilliant people, but they can't put it to good use and help come up with some solutions right now.
It's true.
But anyway, let's jump into some, proactive steps, a top 10 list. And these are some takeaways that we hope will be helpful. And I think the first thing that we wanted to talk about was developing your plans for 2020 and beyond. None of us know how long we're going to be at a point where there are lockdowns, restrictions, how long we're going to have even more employees telecommuting, on a going forward basis. So we're at a point where all of that's uncertain. And one of the things I think that's really important is to start to plan, what does your business look like in terms of where are you devoting your resources? Which employees are going to be working in an office? Are more employees going to be working remotely? If you have half of your workforce working remotely, do you need as much office space as you presently are occupying? And start to plan. How are you going to build out your teams? What type of hiring are you going to be doing in light of this? Think about things like employee retention and what's the impact, of having more people working remotely on retention. Will it be easier for you to continue to have your employees working for you? There are a lot of questions to identify in planning out on a going forward basis. And this is a really good opportunity to do that. As I said at the outset, perception. The perception is this is a golden opportunity to make some tweaks in how you're running your business and be consistent with your brand and your core values. Katherine, can you talk a bit about employee manuals and the employment agreements given the pandemic?
Sure, absolutely. So similar to what you just said, this really is a golden opportunity to review our plans as well as our manuals and agreements. This is a super appropriate time for employers to review their anti-discrimination policies. We can also ensure that the policies include a comprehensive internal reporting process, and we can also make sure that all of our employees are aware of those reporting processes and that they're aware of harassment reporting plans too. It's also a good time to remind employees of the anti-discrimination policies, make sure that they're up to date, that they're well trained on exactly what's permissible and what is not. And if business is slow, now is an opportune time to ensure that employees are up to date on all internal policies and really make an effort to strengthen compliance within your business.
Speaking of the policies, one of the things that it's important to consider, and one of the reasons why this is on our list, is does your employee manual adequately address your policy with respect to telecommuting? What is going to be expected of people when they telecommute? Is that properly addressed in your manual? Does it talk about things like how you communicate? What are you doing with documents? For example, if you've got documents that are private or privileged or your trade secrets, can your employees who are working remotely put those documents out at home? And now they've got your very valuable, but your pride and joy in their house, in their apartment, with other people from friends or family who might come by. Have you addressed things like that? With your employment agreements, again, please address your employment agreements and also things like independent contractor agreements and determine whether or not they adequately protect you given the environment we're in. And then, the other thing is how you communicate with your team. When you've got to do layoffs or you've got to furlough or you're reducing compensation by a certain amount, the people who are on your team see what's going on, and they have a lot of questions, and they have got concerns, and they're scared. As Katherine mentioned earlier, this is a time where there are quite a few people who are afraid. They're afraid for their health. They're afraid for their economic security. This is an opportunity to communicate with your team. Hold meetings, at least on a regular basis, like once a week. Top-down involvement in the meetings, and talk about what's going on. Show your team you care about them. Talk about what your plans are going forward. Talk about what you're doing. Talk about what you're trying to do on a going forward basis. And one important point, and this is actually a really important hot tip, don't make a promise to your team unless you're sure you can keep it. We're going to be up and running by May 15. Really? Are you sure? Or is that a hope? Or is that a best guess? Just don't promise what you're not sure you can deliver. And the better you communicate with your team, the more you show them that you care, that you are doing everything within your power to navigate through these choppy waters, the better off you are. And then the next thing that we're going to do is identify things that we need to do to fill gaps, to fill holes. So, for example, we've got a person who is leading a team and worked in the office. Everyone was in the office and everything is all well and good. But Alec is now leading a team remotely. Does Alec have the ability to lead that team? Does he have the know-how from a business standpoint? And then from a legal standpoint, does he understand, as Katherine had talked about earlier, that we've got to be mindful of the schedule and the hours that people work? So Alec can't just, reach out to people whenever he feels like it. He's got to do it when people are working. And keep in mind that, people have to work a certain schedule, and they may be entitled to breaks depending on what state you're in. And you don't want to be expecting an immediate answer, before the workday starts, after the workday ends, or during their lunch hour, because then you've got people, especially if they're not exempt, who would be entitled to overtime. So we need to train the people like Alec so that they understand when they're going to reach out to their team. We also need to train them to make sure that they're not demanding that people on their team work off hours and not put in for the time. We need to talk about how we communicate. Raise your hand in the audience, by the way, if you ever got an email or a text message. That's right, put your hands up, and you weren't quite sure what the intent of the message was. Okay, I think I got 75% of the people on this webinar have their hands up. The other 25 are probably sleeping. That's okay. But seriously, people misunderstand emails and text messages. I think we need to teach the supervisors and managers that if there's anything that they're putting in and they're not sure about the message, call the person. Or put it down, pick it up a few minutes later. Last point on this topic is if you're annoyed or you're frustrated, don't send the message out just yet. Put it to the side, maybe get a peer review, calm down a little bit, and then you send the message out. Because once you send it, whether it's through an internal communication system, whether it's a text or it's an email, just don't send it if you're not sure how it's going to be received. Okay? So, Katherine, can you talk a bit about some steps regarding the employee engagement and retention?
Sure. Before I do, I just wanted to make one point that ties together the communication with the team and also your previous point. Just a bit of advice for Alec, who is, this new manager now managing his team remotely. It would be important for Alec to ask his team open-ended questions. Ask them, how's working remotely going for you? He should ask the employees, do they have all the resources that they need? Asking open-ended questions can be really helpful. It can be an excellent information gathering tool. And employees will oftentimes be able to share issues that they're running into that sometimes maybe the management team doesn't even have on their radar. So communication is really an integral part of making sure that telecommuting and working remotely works smoothly. So jumping into steps regarding employee engagement and morale and retention, with individuals working remotely, teams should absolutely have regular check-ins. David had touched upon that already, but these regular check-ins really help to keep employees engaged. Oftentimes employees can feel like they're working in their own little silo at home, and sometimes when you're out of sight, you're out of mind. And it's important that the team really continues constant communication. It will really help. And in addition, the more unified that the group is, the more forgiving that employees will actually be if the employer has to employ any reductions in pay or furloughs. They'll feel like they're part of a team, and they understand that some team members need to take a hit for the benefit of the good of the entire organization. David, did you want to talk a bit about auditing employee classifications?
Sure. And I have to preface this point with an apology. Nobody wants to audit. We know that, and you know that's a burden that we put on our clients, and unfortunately, this is one of those times where it's important. We talk in general when we're not in the middle of a pandemic about things like auditing for equal pay and affirmative action. And those types of audits should still be taking place because the equal pay is still the law. Affirmative action is still something that's really important. We want to make sure that we're dotting those I's and crossing those T's. But now we've got that issue that we touched on earlier, and that's employee classification. Is the employee exempt or not exempt? And that's really important because if you go by what the job description says, maybe the person, is correctly classified as exempt or not exempt. That's all fine. But we know that when we're not in a pandemic, oftentimes we have a job description and what the person's actually doing is very different, and it changes over time. So we get into misclassification issues on a regular basis. Now that we're in a pandemic and we've got people who are working from home, their job description and what they're actually doing is going to be very different. They may not be making major decisions. They may not be supervising or managing a team. They may instead be now at a point where what they're doing does not meet the criteria to be considered exempt. And if that's the case and they are owed unpaid overtime, that gets to be an expensive proposition. There may be, in addition to compensation, they may be entitled to different kinds of benefits. Another thing that we want to audit is how are we tracking hours? We don't want to let anything slip through the cracks. Are we properly recording when the workday starts, when the workday ends? If it's not exempt or they're hourly, are we properly tracking when they're taking their breaks and when they're back to work? And this is important from a business and a legal standpoint. From a legal standpoint, again, we don't want to miss any overtime. We don't want a situation where there was perception that a person was threatened not to record overtime. And then from a legal standpoint, a business standpoint, we also don't want employees who are clocking in and they're surfing the internet and they're playing solitaire on their computer when they should be working. We want to make sure that they're doing a proper day's work. And something that I didn't mention earlier, and I should have, is make clear when you talk about your policies and your manual that we're defining expectations of employees when they are, working now. What do we expect of people working from home? And are those expectations reasonable? And how are we going to track those expectations? We may even need to change performance evaluations or how we're, evaluating during the course of the week-to-week management of our teams. Speaking of, tracking things and keeping track of our employees, Katherine, can you touch a bit on traditional training?
Sure, gladly. Before I jump into that, though, there's one more audit that should be conducted in the context of furloughs or reductions in hours or terminations. And we had touched upon it briefly earlier, but I did want to reiterate that it's super important to conduct impact analysis to protect against disparate impact claims. We really need to ensure that there aren't any particular protected classes that are inadvertently being targeted. So that's just one more audit that employers should be aware of.
Great call out. Thank you, Katherine.
You got it. So yes, in terms of traditional training, if your business is in a state with mandatory training requirements, you still need to meet those training requirements, right? So those rules are not excused because of the ongoing pandemic. I know that a lot of businesses are currently focusing on other things, but if there are mandatory trainings, please make sure that you're still meeting those requirements. Another traditional training that would be helpful is training the management team. And as David had alluded to earlier, that training might be a little bit different now that most teams are working remotely, but it is really important to make sure that the management team is all on the same page, that they have all the tools necessary to be able to properly guide their team and manage their team remotely. David, were there any other traditional trainings that you wanted to touch upon?
I think you've covered it, but keep in mind that you've got to check the box with respect to training in the jurisdictions where the employees are working. So please make sure that if you've got employees who live in one state and work in a different state, that you're familiar with the local and the state laws in the state where the employee is actually performing his or her work, to make sure that you satisfy your requirements regarding the training in those different jurisdictions. But just keep in mind that laws with respect to hostile work environment, disparate treatment, adverse employment actions, and any other form of discrimination or harassment, those laws are not relaxed because we're in a pandemic. They're still there. And it's still possible that employees can sue if they feel like they have been harassed or they've been discriminated against. They can sue, and they will find, lawyers to take cases. And in the environment we're in right now, when employees are more concerned about money than they have been in quite some time, they may be more likely to bring lawsuits against you, if they see that opening, because they may look at it as a potential windfall for them. Okay, thank you, Katherine.
Yeah, that's a great point. So the next point that I want to discuss a little bit is on the health and benefit plan side. Several state insurance commissioners have ordered insurance companies to allow employers to continue covering employees under group policies. That's even if employees would normally lose their eligibility due to layoffs or reduced hours. So now is a really good time to check in with your insurance companies to understand what your coverage is, and also to make sure that you know what your potential employer liabilities are.
That's a great. We also want to talk about centralizing decision-making, and this is important because when people are working remotely, oftentimes it's very easy for things to happen where the left hand does not know what the right hand is doing. So what may happen, for example, is an employee may request an accommodation and another employee requests an accommodation, and you've got two different decision makers. One says yes, the other one says no. The one that gets a negative response is aware that the other person got that accommodation. They're going to cry foul. And if that person falls into a protected class, oh, wait a minute, pretty much everybody does fall into a protected class, they can get over to that famous law firm. And I know some of you have heard me say it before, but you're going to hear it again. They're going to walk in the door of Dewey, Cheatham, and Howe. Or actually, it's a pandemic and we're social distancing. They're going to call, and the phone will be answered, Dewey, Cheatham, and Howe, may I help you? And they're going to be saying, it's not fair. I didn't get the accommodation, another person did. Or if a person, is being let go, furloughed, a reduction in compensation, they're going to be thinking other people are not getting furloughed, are not getting a reduction in pay or laid off, and they're going to compare themselves to other people. So companies need to centralize the decisions that are being made and make sure that they're being made by that central group. And that group should include If you've got an in-house attorney, your in-house attorney. If not, you should have an employment lawyer that you're working with. It should include your HR team. It should include leadership and make your decision while you're also doing what we talked about earlier in terms of decision making on a going forward basis, not just for the next couple of weeks, but for the next couple of months, if not 6 to 12 months into the future. If you organize the decisions that you're making, and by including HR, you know that you're not going to have a disparate impact on any protected class. If you properly trained your managers, HR is going to know if anybody has made a complaint or requested any kind of an accommodation. And at this point in time, you have that information in front of you. Then you're going to be making intelligent decisions for the right reasons. So by centralizing the decision making, you're consistent in how you're applying it, and you're going to dramatically reduce the risk of any kind of a claim for retaliation, for disparate treatment, disparate impact. And I think you're also going to have a much happier workforce. Katherine, can you talk a bit about that famous D word, documentation?
Absolutely. So this goes without saying, we've mentioned it before and we'll mention it again here because it really is of the utmost importance. If you're making any changes to your policies, if you're engaging in the interactive process for a request of a reasonable accommodation, or if you're taking any action to terminate employees or reduce their hours or their compensation, please document as much as possible. Now, this can only come back to be helpful for you as a potential defense if there are any claims that are levied against you. If a discrimination claim is brought against you, a judge very well may ask what you have to show that what you did is legitimate and is not discriminatory. So it's really crucial for you to document every step of these changes and these processes. And then just as a reminder, please also be aware of where you're storing the documents. I touched upon this earlier when I was discussing some of the privacy concerns, but if you're taking any kind of confidential employee protected personal health information, make sure that you're storing it separately from the personnel file. And make sure that it's in a secure location so that confidentiality is maintained.
One of the things that I love to ask clients is, what did they have for dinner last night? And most of the time they're able to answer the question. The ones who cannot answer the question, they concern me a little bit. But think about this for a second. Think about this. You ask them what they had for dinner last night and you get an answer. Then you ask what they had on an arbitrary date 3 or 4 months in the past, and unless it happens to have been the person's birthday, chances are they've got no clue what they had for dinner. So why do I say that? Simple. If you don't document when things happen, it's very difficult to remember several months later what happened on that date. So it's really important to get your team to document, your managers, your supervisors, employees who are working with one of your customers or your clients. When decisions are being made on a company-wide basis, the documentation at that time is the way to maintain a record so you know what happened if you're asked about it several months into the future. Get your team to do that. It makes such a big difference, and I can't urge you enough to do that. So that brings us to the end of our program today. Thank you for joining us. The reason why Katherine and I did this webinar, and the Wagner Law Group has done a host of other webinars, and if you go to our website, you can access those webinars and a lot of material about COVID-19. The reason we're doing this is we're doing everything we can to help all of you navigate through this difficult time for businesses and for individuals. And we're both here and happy to answer any questions that you have. There is no such thing as a bad question, so please feel free to reach out to us anytime that you want. And thank you all. Katherine, thank you for joining on this webinar as well.
My pleasure. Thank you, David, and thank you to all the webinar attendees. We really appreciate it.
Take care now.